India Limited.
Yes. So this is the departmental issue, my lord. I cannot suffer since 2016.
Is
Now
Coal India representing?
I have served copy.
My lord, Coal India is not representing, but in this particular case, it is the fact it lies is that a portion of the NCWA of that is 9.4 has not been approved by the management as well as by the trade unions and the central by the government of India. There are JBCCI. There is a committee constituted.
Absolutely. First statement. May I complete, my lord? May I complete, my lord? Now, page 140, 144, if your lordships kindly come.
Yes.
This is the order passed by this honorable court in the earlier round of litigation. Paragraph 6. It is also not the case made out by the Coal India that the petitioner has not fulfilled the terms and conditions of the NCW agreement. The record simply shows that the application submitted by the petitioner is pending as under process. Now, my lord, in 2016, my father has become incapacitated. They have processed my employment. They conducted my medical examination. Now, when I approached before this honorable court in the first round of litigation, they have taken this, my lord, stand as my lord, I want to your lordship the affidavit portion that there is a provision and the entitlement is there. Now, this was the observation. Based on this observation, my lord, they had to consider my case. Now, they have considered and they are saying that unless and until implementation instructions is issued by the Coal India, they are not unable. Now, if your lordships kindly see your lordships, my lord, the last order, not last order, my lord, initial order, my lord, directing the authority to file report, kindly see.
Yes, a report has been filed.
No, your lordship's observation may kindly be, my lord, seen, my lord, in the first day, possibly I cannot remember the date, my lord.
All right, let me see. Yes.
Kindly see your lordship's order, my lord. Your lordships also specifically observed under the NCWA 9 because I have shown all the, my lord, books and the provisions on the initial day, my lord. And lordships has already, my lord, asked them, my lord, to, my lord, for favorable, my lord, report. In NCW 9, I have covered about the initially when my father was incapacitated, NCW 9 was there. Now I will show to your lordships the another order. The two order was passed by this honorable court in the earlier round of litigation.
Yes.
There was two writ application was moved. Another writ application, Siva City, my junior will, my lord, so to your lordships the order. The order dated 17 December 2025. Same order was passed for consideration.
Yes.
Same issue. And my lord, the incapacitated was also, my lord, the same year. Everything is same. Now, in terms of this order, my lord, they have passed the reason order. My junior will show to your lordship the reason order. And my lord, your lordship will find in the reason order, they have agreed, my lord, absolutely contrary view. They have already agreed and they have provided the employment. Now they are saying, my lord, another matter, but my lord.
Oh, Shiva Shetty is already there on record.
Yes, I have shown to your lordships.
Yes, yes.
I have shown to your lordships. Now they are taking, my lord, contrary view in the different matters. In the reason order, in page number, paragraph 3.5, your lordship will find. Now, kindly see, my lord, Shiva City was submitted. Both the dates are covered. Yes.
Last portion it mentions it will be considered sympathetically and the employment shall be processed on priority basis.
I am told that the employment has already been given because this is a February's order, reason order.
Both dates covered under NCWA 9.
Yes, based on this,
there was no consensus over the clause 9.4 and was referred to subcommittee, but the instant matter comes during the period NCWA 9.
Yes.
And as such, the petitioner Shiva Shetty is entitled for compassionate appointment. Yes. What is your date?
My date is, my lord, the 29th June 2016. And your lordship already observed in the all this fact I was placed, it was placed before your lordship.
All right, let your learned friend make submission.
Kindly see your lordship for the first order directing the authority to file
Yes,
report.
March 6, terminated on 29th of June 2016. NCWA was in operation.
My lord. And in the report, my lord, they have said, my lord,
30th of June 2016 and 29th June 2016, just one day prior to
yes.
the NCWA 9 was
And my lord,
possibly 10 came into effect or something.
yes, and now my lord, practically
NCWA
till
6.
my lord, in practically, my lord, till date, this provisions is applicable. I have also annexed in my writ application the order of single bench, division bench, Supreme Court, and they have provided till date they are providing employment. I have, my lord, annexed all the appointment letters. My lord, kindly see my writ application. All appointment letters I have, my lord.
Have you filed a report?
Yes.
On the application itself, I have filed.
The report has been filed.
Page 136, kindly see.
And did you file an exception? Do you want to?
They, in the report, my lord, they have not said nothing. Kindly see.
In that case, the court will hear and pass necessary order.
Let them file an exception.
Why? They do not choose.
Taken the stand that
No.
The petitioner doesn't choose to file an
It's not
exception. What can
necessary.
be done? He says it's not necessary.
I'm taking my submission, Your Lordship, as per the instruction I have received from my.
Very well. In that case, let it appear for hearing. Please come. Learned advocate for the petitioner submits that his client.
Well, they have not denied employment in their report, in the latest report also. Kindly see.
Yes.
They have not denied employment.
Very well.
They are asking the
petitioner submits that the petitioner would not like to file an exception to the report filed by Eastern Coalfields Limited and would like to proceed with the hearing of the writ petition. Stop paragraph. In view of such submission, release the matter for hearing. When do I keep it? After the vacation?
Yes, madam.
When?
Any day, madam.
15th of June.
Madam.
1 week after vacation.
Madam.
WB side.
On the prayer of the learned advocate representing the petitioner,
this, but Your Lordship was taking the
seeking extension of time for filing the supplementary affidavit. Hearing of the writ petition stands adjourned till 15th of June. Supplementary affidavit shall be prepared and circulated by 10th of June.
I had taken the point of maintainability.
If it is there, very well. Next day I'll see.
Yes.
Let the supplementary come.
Yes.
Same order in the next matter?
Same order.
All right.
Yes.
Yes, your client doesn't want to proceed.
Has discussed with the and they instructed that if they show the case, they will settle the account and
whose account? Arun Kumar Das was the petitioner. He has expired. All right, and doesn't want to proceed. Please come. It has been submitted by the learned advocate representing the petitioner that the sole writ petitioner Arun Kumar Das has expired. When? On blank.
28 November 2025.
Stop. The heirs and legal representatives of the deceased writ petitioner are not inclined to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands dismissed. Give the death certificate. It can be written with the records. All right, give.
Lordship, in this matter, Dr. Shahada is appearing for the WBSc DCL. He is lagging in courtroom number 41, Lordship. I am praying for short password, Lordship.
What is the matter about? Tell your mother to sit. Yes.
They came to my house, took the inspection of my house, and this is what page number 47.
Yes.
This is the spot your lordship kindly your lordship on the same day, because we used to send out the bills. They sent another or different units. That is at page 45. Regarding that, your lordship, I send you.
Page 45. What is the bill amount? 3135. No, total is.
The bill of 5 October 25.
Yes.
And we 3,753.
Yes.
The lordship, they used to raise bill to estimate sometimes physical bills. Your lordship, I have paid this. That is at 46.
How much have you paid?
2042, your lordship, November, December.
How can, where from are you getting this 2042?
Your lordship, for October I have paid, and this is the.
I can see the gross amount is 3135.
Your lordship, for October also I have paid, and it is the bill of November and December.
Which one? Page 45, I can see 313576 is the figure.
That was also paid. The October's bill has been paid in October, and it is of November and December.
Which one is for November? This is for October, page 45.
But it has to be paid for October, November, and December. And this bill is of November and December. I have missed all the visit in my earlier.
Now what has happened? All right, page 47.
47 spot bill. They have issued spot bill. Your lordship. The spot bill they have issued.
No, you have annexed this.
Yes.
Photocopy. Yes.
16 January 2026.
Right.
Your lordship, thereafter on the same day they have raised another bill. Your lordship, on this bill, they said that the total amount is 8916.
Right.
Your lordship, on that, your lordship, we have sent letters. Your lordship, this kind of activity has been done by them earlier also, your lordship. So we have sent notification of the representation that kindly tell us which bill has to be paid and rectify the bill. That is appearing my representation. And actually, your lordship at page 40.
Is this all domestic electricity connection?
Yes, your lordship. It is father, that is in.
Why have you not changed it?
Your lordship, we have applied, so they have asked for 1 lakh rupee. After that, they have settled for 72. Then also they said that you are the wife.
No, Lordship. This is mischief allegations, Lordship.
They are saying it's allegation, your lordship, but I don't have any.
Have you paid 72,000?
Yes, your lordship. Earlier I have paid. I don't
To
have
whom?
any receipt.
To whom, Lordship?
But
That is the main point, Lordship. That's why previous Lordship has exhausted and the matter.
no, it may not be in the issue, but then why will the bill continue in the name of a dead person?
Yes, Lordship.
26 years, your lordship.
Then it should have been changed. What steps have
They are
you
not
taken?
giving the access to inspect our meter, Lordship. That is the main problem. Kindly see the Lordship statement of fact,
One
Lordship.
minute.
Yes,
Yes.
presentation. Reminder of my earlier representation, they have not changed the bill, they have not expressed the bill. So I have given another representation. Now, your lordship, page 52, their representation, their reply,
Yes.
that the meter has to be changed.
Huh?
Your lordship, even if the name has to be changed from the name of my husband to my name, it's administrative paperwork, your lordship. For that, they cannot change the meter, your lordship.
What is this so special in the meter? If they find it to be defective, they can change it.
Your lordship, not independent action. I bow down to your lordship if it is an independent action, your lordship. What they are doing, your lordship, they are raising illegal bills, exorbitant bills.
Why? What is their gain? You are not the only consumer of WBSCDCL. You are a domestic consumer. You do not have any commercial activity over there. What benefit will the WBSCDCL?
9 January 2024, I gave a representation for an illegal connection outside my home.
Who is using those connections?
Your lordship, other people, and I have given representation to disconnect that supply, your lordship. After that, it's all started. In collusion of the local people, your lordship, they started acting. Your lordship, in a years, after that, whenever they do disconnection. And after that,
No, but then the units that have been consumed, is it by you or by the outsiders?
your lordship, not me. But I have complained about another illegal connection outside the field, and that is for the safety concern, your lordship.
Now that is over.
Yes, your lordship.
Now do not have any illegal connection outside.
Your lordship, it's still there, your
Still there was connection, and you are no way connected with those illegal connections
lordship, it just passes from the behind of my house.
behind your house, but then no way related to your house
Your lordship, no, it's not.
and not to your meter either. Right? So whatever the bill is, it is your bill, and it is you have to pay.
Regarding the bill. Your lordship, I just said that on the same day, you are issuing one spot bill saying that the bill is 104, and the same day you are issuing another bill and saying that the bill is 8,000. Kindly rectify the bill and so that I could pay.
All right, now show me spot bill is page 47.
Yes, your lordship.
Right?
After
With
that,
the
your lordship,
Hmm.
I have not rectified it, but after when I came to the liquidation, your lordship, then I came to the board and moved on requisition, your lordship. On that same day, they said that yes, we are taking action for rectification of the bill. Your lordship has given us an order for the inspection of the meter. Your lordship, on that day, your lordship, we were there, but they have not come, your lordship. We are not, it is not in our knowledge, your lordship. Later on, your lordship, on the, my spot bill issue was not heard by the honorable single bench. That's why, your lordship, I preferred one appeal. Your lordship, in the appeal court, your lordship, the honorable judge said that you have to raise to before single judge only. I'm opening this point that you can raise these points before the honorable single judge only. Your lordship, we again came back on 19th of March, that appeal court order was passed, your lordship. And on your 20th of March, your lordship, when we came to the honorable single bench, your lordship, I could not appear. I tried to enter online, but I could not appear, your lordship. I was not allowed to enter online. Your lordship, your lordship, they have not given 1 day time to me. Your lordship, on the next working day, 20th Friday, 23rd, your lordship, they went to my premises with the police personnel, huge police personnel. They have misused their power, overpowered, as because, your lordship, there was no instruction for the police. They went with the police, they inspected the premises, and your lordship, they attacked the petitioner, your lordship. What they did, your lordship?
Why will they attack the petitioner? They are goons or what?
Your lordship, with the collusion of the local people, your lordship, para people, what they did, your lordship, they entered into the premises first floor, they cut down the trees grown over there, and then, your lordship, they made illegal connection over a pole which I have objected earlier, Your Lordship. On 23rd, they made a disconnection. Your Lordship, on 20th, when the writ petition was dismissed by the Honorable Single Bench, a liberty was granted to them to move as per Section 163 of the Electricity Act. Your Lordship, as per Section 163, Your Lordship, what they did, Your Lordship, kindly see, this is the main concern of this writ petition, Your Lordship, because after that, Your Lordship, I also filed again one appeal.
Is it page 52? Which page?
The second notice, Your Lordship. May I show you the order of the division bench, Your Lordship? The second time division bench order, Your Lordship, after dismissing of the writ petition.
If your Lordship kindly takes the report which has been filed, all orders has been annexed with that report, subject to your Lordship.
First submit, Your Lordship. This is the order.
I will. I am not opening my mouth right now.
Your Lordship, Justice, Honorable Justice Sompa Sarkar and Honorable Justice Ajay Kumar Gupta has said, Your Lordship, that you have to raise this question again to the Honorable Single Bench because and regarding the maintainability, regarding the disconnection, you have to file press proceeding. And that's why we are here before Your Lordship. Your Lordship, we have also filed review application that is about to be heard by that Honorable Single Judge. And Your Lordship, this is the petition, Your Lordship, for the disconnection. Your Lordship, on 28th, the matter was dismissed. On 23rd, the second working day, I was in the division then mentioning the matter for the urgency, Your Lordship. But on the 23rd itself, they have attacked the petitioner, cut down the trees, made illegal connection, and disconnected my supply. Your Lordship, kindly see page 50. Page 52, Your Lordship. It says 53.
53?
And exactly for Your Lordship, page
Yes.
53 and
Yes.
page 54.
Yes.
Your Lordship, after disconnection, Your Lordship, they have issued this notice. Now, Your Lordship, may I kindly show you the law? Your Lordship, kindly see this notice.
1 minute, page 53, what does it say?
Your Lordship, page 53 says that we have came for the inspection, we have not allowed so, and as per section 163 of Electricity Act and clause 8.1, 8.12 of WBERC 55 regulation, we are disconnecting the supply. We came with SSLT forces of Anpara police station, and we are disconnecting the service line on 23rd March at 11:45 AM from the nearest pole, finding no other alternative. Your Lordship, on the second notice, kindly see, the same thing is there. It is about notice that we want to do inspection. And it was written door lock from inside. Your Lordship, on 20th March, they have also filed a report. Your Lordship, on 20th March, my name was given there, but I was not appeared, and I have not received the report also. But on the last occasion, they have served me a report, Your Lordship. The signature of the witness was that whom against I have complained to the police again and again for illegal activities over my property. And Your Lordship, kindly see this notice. These two notices, Your Lordship, after disconnection. And Your Lordship, kindly see what the law says. May I kindly show you the law? Section 160.
No, let me understand from your learned friend what he has.
I will clarify the entire scenario, if your Lordship allow me.
Yes.
But this is a
Right
very...
now, you do not have electricity in your house.
Your Lordship, from 23rd March.
All right.
But this is a very peculiar scenario brought before your Lordship. Why this matter has been released on the earlier occasion that the Honorable Court was pleased to specify to resolve the issue.
Yes.
Why I am telling you that on the first occasion there are three issues. First of all, there is no privity of contract with the petitioner. They are running the meter in the name of a deceased person. Till date, they haven't made any sort of application for transfer in a prescribed form. And we have already told them, you come to the office, we will help them. But they haven't, they are reluctant to do that. Second, kindly allow me, I haven't said anything. Please don't disturb me. Now, second point is that, so far why disconnection has been made. In the first round of that notice has been issued to them that you give us the access to the meter board. Meter cannot be the personal property of anybody. Meter is the property of the licensee, of the authority. And we have given them a notice. They kept the door locked And
Do you want access to read the meter?
I tell you, Lordship, what happened. That's why I'm saying what they have done. Kindly take note on that. Then, on the basis of the first writ petition, in the first order has been made to grant us the inspection to the said meter board. What they have done, they have preferred an appeal against that order. That appeal has not been entertained. Again, this writ petition has been taken up for hearing, and in this writ petition, specific direction has been given by the Honorable High Court. In spite of direction given by the Honorable High Court, they failed to comply with that order. And on that basis, further direction has been given to inspect. Now, on that basis, if the inspection has not been given, then as per section 163, I will show to your Lordship, then on that basis, disconnection can be made.
Why you want inspection? To
Inspection
read,
to access the meter board.
to read the meter?
Yes, that has not been done. Now, Lordship, kindly take note on that. On the second note, if your Lordship kindly take my report,
Yes.
which has been filed before your Lordship.
Hmm.
Here, in the first, that is appeal, it has been specified if the inspection has not been granted, the division may specified under section 163 that the electricity licensing company is authorized to disconnect the meter. I will show from the law as well as from the regulation, the meter cannot be the property. The licensing authority has got the full authority, to inspect that, but it has not been given. Now, secondly, your Lordship kindly see that, if your Lordship kindly see my report, it is, if you kindly come to, I am not traveling the order. If your Lordship has gone through the order of the division bench, in spite of that, I am traveling your Lordship to see the division bench order. That is the MAT 565 of 2026. Lordship got that?
Yes.
We find from the order paragraph 3 onwards.
Yes.
Order of the Lordship has specifically noted, kindly take note, non-cooperation by the appellant and held that the appellant had approached the writ court with an unclean hand. His Lordship allowed the WPCL to exercise power under 163 of the Electricity Act. Under section 163 of the Electricity Act, every licensee or distribution company has a right to enter into a premises in which supply is granted for inspection, testing, repairing, altering meter. I will show from the law also, because regulation 8.1 specify that we have got the every right to access. Your Lordship knows, your Lordship has also done that. The licensee can also ascertain the amount of electricity supplied to meter or consumer. The licensee is further empowered to remove any supply which has no longer required. Subsection 3 of section 163 empowers the licensee. Lordship got that? To cut off the electricity in the event it is found that consumer is not cooperating with the licensee and resisting inspection. His Lordship has categorically held that despite the order of His Lordship allowing inspection of the premises, the consumer did not cooperate, although it is specified the appellant has no resistance. Now, if say that they have got no resistance, if your Lordship kindly turn to, I am coming to the bill, if your Lordship kind to next page, this is the bill which has already been regenerated. They have complained about the bill dispute, and on that basis, it has already been regenerated. If your Lordship kindly see, it's the internet copy. Lordship got that? Now they can get accrued this bill from the internet, but they suppress that. They haven't taken this in the writ petition. Kindly see that when this bill reading has been taken and the bill date 28/2/2026, but they have suppressed that. They have not. Nobody can pollute the stream of justice. Now, Lordship kindly come to now.
Wait.
He has not developed the internet copy. It is not to be received. It can be approved from the internet also. Now, Lordship kindly come to next inspection report. In the inspection report, that is the first order passed by the Honorable High Court 13/3/2026. When we have gone for inspection, from their conduct, it is very much crystal clear. They have preferred an appeal. They didn't allow us to make an inspection. We have gone for inspection. There is a local witness, WBCL. We are not allowed. The door was locked. Then your Lordship kindly see, again we have given letter to the inspector. Lordship kindly turn to next page. They are saying, whatever they are saying, this is a gospel truth. Kindly come to 13/3/2006, we have reported to the police authority. But at that time, kindly note, we never disconnected that line. Again, this Honorable Court was pleased to pass an order, if your lordship kindly see, by the single bench, that is on.
No, just tell me one thing. Is there any amount that is due and payable?
So far the amount due and payable is concerned, at this juncture I have to check whether there is any due amount. There are three issues. Lordship kindly took, their matter can be resolved
Yes.
once and for all.
Right.
I have already told them, but they never cooperate. First thing is that the meter has to be changed in the name of the, this is in the running in the deceased person, it has to be changed in the name of some in a prescribed form. Till date, it has not been made. This is the first. Second is we are not getting access to the meter board. It is in their internal problems that their privacy will be lost. So we have said, we have specified in the report, you just cooperate us, we will transfer the meter board outside the premises at our cost. Even it is not to be given, but so far we have said at our cost, we will specify and transfer the meter board outside the premises so that we can get easy access to the meter board and it will not invade your privacy. That we have said, they are not cooperating. Thirdly, we have said that so far the meter is concerned, it is a conventional meter. Your lordship knows the old meter. Nowadays, ST meter is to be given. We have given the circular also, government circular, that is in the last page. Your lordship also knows. Now, electronic meter is to be given. They are not cooperating. They are relucting. They are saying our meter is okay. We are not going to transfer.
These are the three
These are the three issues that can be resolved, but they are not cooperating.
All right, just wait and see.
Lordship, we have kindly,
Tell me one thing. What steps have you taken for transfer of the meter?
your lordship, I would apply any formalities as your lordship would order.
Your father has expired long back.
26 years back.
What steps have you taken?
Your lordship, we went to the office. we
No,
did
not-
representation.
Not representation is not the thing. You are a practitioner, you know. And this is your personal matter. It's not that this is your client's matter. So you know each and everything. What steps have you taken? You are moving court in each and every occasion.
That's
Why
why
you
the
are
matter has
taking
been
steps for getting your name changed?
Your lordship, we have done so.
Where? Show me one application.
Yes.
30 years back, document is not with you right now.
For the last 25 years, you do not have a single document to show that you have transferred.
25 years, they have not done so.
Who has not done?
The Continental Customer Care Center,
We
What have you done?
your lordship, we have done, so.
Show one document.
There is no document.
So I disbelieve you. Do not mislead the court.
Your lordship never, your lordship kindly. wait.
1 minute, I am not going to see your phone. First thing, transfer has to be made. Second, why are you not providing access to the meter?
That I'm showing that I have provided access.
All right.
Video, your lordship.
All right, you provided access. The meter will be placed in such a position
Yes.
that your privacy will not be invaded and they are not going to trouble you every
Yes.
month or every 3 months.
One thing, your lordship.
Yes.
I have never complained of privacy. If they are saying so that they have told me to change the place of the meter, let them show the representation. Your lordship, representation says that they want to change the meter only on the ground.
Why are you not permitting him to change the meter? Because this is the new meter that is to be installed.
Inspection has been required.
When you will provide, when will you go to inspect?
Your lordship directors will go and your lordship kindly take note of this
1
regulation.
minute.
Yes.
1 minute. 1 minute.
About the meter, if it goes outside, your lordship, the inmates of the place, your lordship, they would do some mischief to the
Yeah.
meter. That's why, your lordship, I have never any issue regarding the privacy. Your lordship, 2 videos are there.
If privacy is not the issue, it is you and your mother. Nobody else stays in the house. The WBSCDCL people will come. Nobody, if nobody is there, how will they get the access? Will
No,
you
we are
say-
not getting access.
If that's, we have never restricted.
No, we are not getting access. Kindly take note on that.
Every occasion, this is his option.
We cannot go and
They are,
It is recorded over here that the door is locked.
your lordship, they are saying so.
Ah.
So,
How do you prove it?
your lordship, may I kindly file my exception?
Is this the thing you want? What do you gain out of the whole thing?
Your lordship, I want reconnection, your lordship. I pray for this.
It will be reconnected provided you apply for the transfer.
Yes.
I will provide your lordship.
And this is the photograph. Kindly see.
Wait.
Yeah.
Pradeep.
Your lordship, kindly. Your lordship, kindly sees the law, your lordship. Section 163 says.
It has been,
Your lord, may kindly.
Uh,
Your lordship, one thing.
it has been, no, the petitioner alleges that WBSCDCL has illegally and deliberately disconnected her electricity supply.
Your Lordship, this notice is beyond 24 hours, Your Lordship. They have to give prior 24 hours notice. They have never given so. It is after disconnection.
Acha.
Your Lordship,
It has been submitted that prior notice
was not given.
My dispute that already given.
Disconnection. Stop. Prayer has been made to direct the respondent authority to reconnect the electric meter. Stop paragraph. The learned advocate representing WBACDCL submits upon instruction that the meter is being the meter in question stands in the name of a deceased person. Stop. Despite repeated requests made to the petitioner, steps have not been taken for transfer of the meter. Stop. Access to the meter. Access to the meter for taking the meter readings are not provided. Stop. Without proper access to the meter, electricity bills cannot be raised properly. Stop. Next. It has been submitted that WBACDCL is agreeable to install new meter,
ST meter, Lordship.
new ST meter at a place where access is easily available and the petitioner will not face any problem if the meter readings are taken. Stop. Next.
Kindly inspection may be done, Your Lordship.
Inspection will be done.
Your Lordship, kindly the
Yes.
connection has to be done. Your Lordship.
Yes, inspection will be done.
Electricity.
Today is Tuesday, by Thursday inspection will be done. Acha.
Concerned officer.
For paragraph diligun to for taking reading of the meter, the inspection is to be provided by the petitioner. Stop paragraph. Release the matter on 21st, 19th, 22nd May. Stop. Inspection shall be conducted by 21st May and report shall be placed before this court on 22nd May.
So far, it's a very short period, 21st and 22nd. If your Lordship desire, then today we are on. Oh, all right. Can't help.
I don't have time.
Can't help.
So they could go, Your Lordship.
Just wait. The court is trying to resolve and you are trying to confuse things. This is.
I am
I
also
do not
trying.
understand that this is your personal matter. Why are you delaying it?
I'm not delaying it, Your Lordship. They have given illegal notice, Your Lordship.
Why don't you take advice from somebody who can
That's
help
why
you
that
out?
court has specified. But they reluctant to show that court has released that matter.
Your Lordship,
For this reason.
coming to the wrong allegations, Your Lordship.
I don't see the allegations are wrong. Difficulty is this.
If you kindly see the law, Your Lordship, it says 24-hour prior.
Already prior notice has been given. They have challenged that. Fast writ petition, fast retreatment, they
What
have challenged.
gain by seeing that notice? Now the disconnection is done.
Yes, Your Lordship.
Why are you fighting unnecessarily?
Your Lordship, that's why I'm.
Try to find out peace. Your mother is growing old day by day.
Yes, Your Lordship,
Give her some peace at least.
that's been wrong.
Acha. Try to conduct the inspection. Today you have got time.
I will try to conduct the inspection in course of tomorrow.
By tomorrow, because
so that I can file the report before your Lordship
Yes.
on 22nd.
because these two people are over here, nobody will be there to provide
And
you.
kindly allow us to access to the meter board, your Lordship.
The officer may go, Your Lordship. They are coming with all the inmates.
Are
and
they?
goods, Your Lordship.
Inmates means whose inmates?
Inmates are outsiders. Outsiders.
Eh,
they are-
what,
they are
my
coming to
landed?
Complain, Your Lordship.
Why will they go?
Your Lordship, the kindly concerned officer may go, Your Lordship.
Yes, only the officer will go.
Kindly note that, Your Lordship.
The-
Concerned officer and the meter reader.
yes,
Both, yes. They will say only one person will be allowed.
Only officers of WBACDCL will enter the premises for
Along with the meter reader.
taking inspection. only officers of WBSEDCL.
Yes, yes, certainly they officers
Whether
are doing.
meter reader or whoever.
But they are saying that whenever 2% suppose meter reader is going and for inspection another WBSEDCL officer is going, they are raising objection, they are putting it in a lock and key. We are facing difficulty. We are trying to resolve it. Even we are saying that we are going to transfer the meter in a place so that their privacy does not disturb. That has not been
Please
done.
come, please come.
Your Lordship, kindly grant me leave to file exception.
Our exception.
আচ্ছা কি বললাম for taking the meter reading are the petitioner shall take steps for transfer of the meter. Stop.
For inspection of the meter, Your Lordship.
Transfer. Inspection is already there.
I have never complained the previous Your Lordship.
It is transfer. It is there in the deceased person's name.
Yes,
It should go to the.
I will do the formalities.
Acha. All necessary formalities for transferring the meter from the name of the deceased person shall be taken by the petitioner within a fortnight from date. Stop. The petitioner shall also cooperate with WBSEDCL for changing the old obsolete meter to the current ST meter.
Your Lordship,
Stop.
it's already estimated.
But it is not an estimate, it is a conventional meter.
Acha. The
WBSEDCL has
the formalities that are required to be complied for changing the obsolete meter to the
estimated.
present ST meter shall be intimated to the petitioner
Yes.
within a fortnight. Stop. The petitioner would be obliged to comply with all formalities for the same. Stop. And you consent to give the access.
Yes, Your Lordship, I have never restricted.
The paragraph diligunto, the petitioner who is present in court, represented by her daughter, the learned advocate, gives consent in open court that access will be provided to the men and agents of WBSEDCL for taking inspection of the meter. Released 22nd.
As your lordship. I will ask them to inspection to be made in course of today or tomorrow. Tomorrow I will, because they are here.
Hey,
tomorrow.
when will you go home?
Your Lordship, no matter, there are persons there.
There are people over there who can open it. All right.
It is always.
Take this back. এটা
open.
ফেরত দিয়ে
Yes,
দিন।
Your Lordship, that it will wait.
I'm deeply of your lordship. At least the matter should be resolved
Yes.
once and for all. I have tried my level best, lordship.
Yes, next. 13. None for the parties. Released on 8th. Service in the meantime. Yes.
I am for the of India. The petition is served yesterday only. I have no instruction till now.
Let me just understand what it is about.
that we are suffering from legal problem with taking from Meghalaya to Kolkata. There are so lot of
We means you are the mother.
then my daughter, my daughter went and my daughter went to bring her brother in Calcutta for treatment. My son was married. 16. Now, naming form mentioning the name of the wife is the Numi.
Yes.
Come to page 13.
Yes.
Report.
Yes.
This is family details, family details, Mamata Goswami, Borosha Goswami, Momita Ghosh, Prakash Goswami. Wife. The third person, third person, wife, Momita Ghosh. Next, family details. The family details are combination for family name of the father. Next of kin, Momita Ghosh. Now, by this way, she will get the interval. Then come to my next one, page 34. My next one.
Yes.
Name of the fount is not here. Can you see? And age of the age of disease, 38 years, name of the fount, blank. Fount certificate was not. And this is one of thereafter we made a representation before the Deputy Inspector General DIG not our representation was not heard. But we attached the order. Come to page 53. Start from the Momita Ghosh has a previous marriage. That marriage was still subsisting when the marriage was done with. Kindly come page 53. Kindly then this one
53 where is the name of the parties?
Come to the first name of the applicant. Filed by the petitioner Orun Thor versus Thor Ghosh. Kindly come to page 81. The suit has been dismissed for default on 11th of January 2020. Kindly.
Yes.
Here also from this marriage, two sons were there.
From Momita?
Yes.
2 sons?
Yes.
Yes.
Where from we gathered there is kindly come to page 180. We record an RTI application on basis of RTI application, requirement given and reply of that. 180.
Yes.
Kindly come serial number 1, teachers. Yes, madam. This headquarters is not having any information regarding dual marriage of Momita Ghosh as per nomination form in service report. Shami has declared she was wife. Moreover, as per information obtained by Sadansa, Govinda Ghosh revealed that he was done love marriage on 1st of May 2016 with Momita Ghosh. My person because it's just 2022 this was no marriage, no marriage. I told him to ask her. She's not entitled to it. This is our my company. Now it's no marriage, or I have no private.
Private respondent?
Not happy.
You served the private respondent.
The respondent number was like 30. That's all. 5 5.
সেক্টর হেডকোয়ার্টার রেসপন্সিবিলিটি নিয়েছে, এতে পাঠিয়েছে। সেক্টর হেডকোয়ার্টার কে পার্টি করেছে, তাহলেই হবে।
Where is the track report? 784. Which page? Four six three. Two addresses. There are two addresses of Momita.
Devasis Kora West Garo.
Dalbagan. And the other is Rashtraguru Avenue.
I serve both addresses. Kindly madam come to page 6.
এটা তো পুরা
Running the 6 madam.
Yes, two postal receipts, 463, one has been received.
784 and another is
14th of May.
463 has been delivered.
Anyway, the authority is not.
As it appears that he was last worked at Tura Meghalaya, and that commandant has not been made party, so we cannot get instructions. Sector commandant is not party, so we will face technical
Give
difficulty
the-
to get instructions.
Give the details. Only Commander Meghalaya will do, or some other address.
Deputy Inspector General Shishumar Pura headquarters. Kindly give Garo headquarters. Party.
But then
Sector is not a party.
commandant has to be made a party.
The party by sector. Commandant. ছয়টা দেখুন, ছয়টা কি হবে? এটা চলবে, এটা চলবে, ঠিক আছে।
If it serves the purpose, then it is all right. Take instructions and come back.
In the meantime,
Also, we don't know whether
Yes,
Already
whether
it
it
is-
has already been released or not. And the
around 120 come to 120.
January 26th, the person expired.
We counter time to
Well, then it is all right. I'll keep it immediately after the vacation. Please come.
already they paid 6,000 rupees
They have.
already.
On which account?
Funeral expense.
তাহলে তো already তো-
Please back up to 120 malas, my back to information. Apply malas, 120.
funeral expenses.
Second,
No any amount disbursed except funeral expenses, 8,000 rupees.
if not paid malas, kindly malas. I'm not.
When the
I'll
funeral
check
is
on the-
released, maybe some part.
The petitioner
Funeral
claims to be the mother of one Govind Kumar Goswami, who was serving in where BSF or key?
Yes.
BSF stuff. The said person expired on 19th of January 2026. Stuff. Submission of the petitioner is that the authority is taking steps to release the terminal benefits of the deceased in favor of the private respondent who claims to be the wife of the deceased. Stop. Paragraph. The petitioner has annexed documents to the writ petition in support of the submission that the private respondent is already married to one Mr. Arjun Dhar. Stop. A suit for dissolving the marriage under section 13 of the Hindu Marriage Act, was filed by the said Mr. Arjun Dhar, being mat suit 876/2014, which stood dismissed for default on 11th of January 2022. Stop. On account of dismissal of the matrimonial suit, comma, the marriage between Arjun Dhar and the private respondent still subsists. Stop. It has been contended that the petitioner is a Hindu and he could not have married a lady who is already married to another man during the subsistence of the said marriage. Stop paragraph. It has been submitted that funeral expenses to the tune of rupees 8,000 have already been released in favor of the private respondent, and there are chances that the balance terminal dues may also be released. Paragraph prayer has been made to direct the respondents not to release any further terminal dues of the deceased till the disposal of the instant writ petition. Stop paragraph. None appears on behalf of the private respondent despite service. Stop. Affidavit of service filed in court is taken on record. Stop paragraph. Learned advocate representing the Union of India seeks time to take instruction in the matter. Stop paragraph. The stand of the respondents is required to be placed on record for proper adjudication of the instant list. Stop. Next. In view of the above, the respondents, including the private respondent, is directed to file an affidavit disclosing its stand by 19th June. Release the matter on 29th June. Exception may be filed by the petitioner prior to the adjourned date. Stop. For ends of justice, the respondents are restrained from disbursing any further terminal dues of the deceased till 17th July 2026 or until further order, whichever is earlier.
I will also kindly direct them to communicate this order to private
Learned
respondent.
advocate for the petitioner is directed to communicate this order to the non-appearing respondent.
Lords.
I am happy with the response number 3 and 4, madam.
On grant of family pending. Petitioner's father was service holder. Father had predeceased father. Father was
Who predeceased mother?
mother. Predeceased father. The father was getting pension and benefits. Passing away on 9th of February 2025. When the application for
Who are you representing?
For 3 and 4, the office of the senior accounts officer and the East Bengal, madam.
what has
Madam, we have
AG Bengal.
yes, madam. We have got the
Answering respondent will be?
state, madam.
Yes. Then, in the absence of the state, it will be difficult. Are you seeking for any interim order?
No scope, no scope.
No scope. Very well. None for the state. Released on 8th June. Let further notice be issued. Service is taken on record.
Get from you.
My lord, I am for the respondent.
21, I am for the petitioner, my lord. As now my learned friend has
You want to file an exception? All right.
I don't think there is any requirement of filing that.
Maybe for his personal requirement, maybe they are.
My lord can dismiss this without even taking the report into consideration.
without giving opportunity of hearing to the other side.
Acha, let me sir.
A report filed by the respondents in court today be taken on record. Stop.
Pass a order.
Report filed by the respondents in court today be taken on record. Stop.
Khali report.
Learned advocate for the petitioner seeks time to file an exception to the same. Stop. Let exception be prepared and circulated by 12th June, released on 22nd June. అది 12th June, released on 17th June. By 12, you can file your exception.
Fine.
Next.
Item number 61 to 21, same order.
All right, you file your report separately so that it may go in the proper file. 17, same order, take the report. Check up whether you got a copy or not. Report in. 18, same order, take the report. Yes, 19, same order, the report.
These are all analogous matters, madam. Only 175 rupees.
Yes, 20.
138.
এটা 290
21 also same.
21
Report.
তুই আছিস তো এর মধ্যে 21 হ্যাঁ আছিস এই তো
28.
এটা ভুল করে 209 পুরো যদি 290 করে না
Yes, 28.
Item number 28, Union of India, Mr. Pradipal for the Union of India.
You were supposed to come back with a report. Give the report. What does it say? None for the petitioner. Report filed by the respondents in court today be taken on record. Did you hand over this report to your learned friend?
No, madam.
No? Not today? All right. Let a copy of the same be handed over to the learned advocate representing the petitioner. Released on 8th June. Exception may be prepared by the petitioner and filed prior to the adjourned date. Give your name. Your name.
My lord, Mr. Pradipal, can I give my senior name?
You give your name.
My lord, please, kindly.
Your name.
He is engaged in court number, madam.
All right, let him come, then I will see. Right now, it is your name.
Yes, madam.
Item number 29, my lord, for the
Yes.
here I have here the exception 1 week earlier.
Not affirmed.
After elections.
All right. On the prayer of the learned advocate representing the petitioner, time to file the exception to the report again stands extended till when? 12th. 12th. Released on 17th.
That here my name has been put in the.
Hi. Call him, call him. Kaushik Dey is there. Call him. Yes. Candidature withheld requiring further examination in consultation with CFSL.
last occasion they to try to produce the report what happened to.
Has any report come? Has any report come?
But my instruction is that my client
What?
intimated me over telephone that
What?
the dossier has been sent to the Kolkata PA.
So it's still at the end of the CFSL?
Not
No
no
instruction.
This order can be passed. The proceeding, one matter to lodge pass an order that if the dossier has been sent to the for forensic case, the CFSL Kolkata was directed to take some test to find out, and in the meantime, if the petition
I
pass.
Learned advocate representing the Union of India submits upon instruction that the report of CFSL is awaiting. Stop paragraph.
तो डाल दिया वो
Achha. It appears that in the absence of the report from the authority, the respondent will not be in a position to proceed with the case of the petitioner for appointment. Stop next. In view of the above, the director CFSL Kolkata is directed to take steps to ensure that the verification process is concluded at the earliest. Stop. The verification report be placed before this court on the adjourned date. Stop. Hearing of the writ petition stands adjourned till 10th July 2026. Stop. In the event the petitioner overcomes the hurdle in the verification process, then his case may be forwarded for issuance of the appointment letter. Stop. Liberty is granted to both the parties to mention the matter in case verification is over prior to the adjourned date. আচ্ছা আর একটা জিনিস লিখে দেবেন যেখানে ভেরিফিকেশনটা বললাম after verifying the case of the petitioner may be forwarded to না এটা লিখতে হবে না do you have a report with you today no report
no further report yet
তাহলে এটা লিখতে হবে না very well let it remain yes
File a report.
Not to file a report, to take instructions.
Has died when he was in service. Living first wife, second wife, and 3 children. Now the first wife claimed the pension, second wife also claimed the pension. Finally, the put him under later, by which they directed the pension disbursing authority to disburse the pension in favor of the members of the family members of the government employee, excluding second wife. That is page 30.
Did you serve afresh the other wife? Nobody is appearing.
Not been delivered.
That has not been delivered. Yes.
But in this matter, I am appealing for the respondent 2, my lord. My lord, in the last occasion, your lordship directed to take instruction in this matter. My lord, I have taken instruction, my lord, that still now no pension papers of for family pension of the respondent petitioner has been forwarded to our office. But that apart, my lord, some communication made through the office of the respondent 2 and the state respondents, my lord. And my lord, I want to file an affidavit since there is no scope of any interim order.
There is no scope for any interim order. You do not pay any money in the meantime.
No, absolutely.
That order has already passed by the
Right. So,
We have not, the file has not been forwarded to our office. There is no specific instruction.
in respect of the other wife also, for her it has not been, but for the other wife,
We can pass an order. Definitely.
an order is there already.
Then I will not.
Let family pension not be disbursed in favor of any party without the leave of the
Let
court.
that we can continue.
It is
Yes.
there. And Chanan appears on behalf of the state or the private respondent. Stop. Let further notice be issued upon the non-appearing respondents. Stop. The respondents, including the private respondent, is directed to file affidavit disclosing their respective stand by 19th of June. Release the matter for further consideration on 6th July. Stop. The interim order restraining the respondents to disburse family pension in favor of any party without the leave of the court shall remain in force.
I'm getting.
Yes. Motion. You mention restraint order is there. You mention.
Gets me.
Next.
Consideration of my PCA certificate of the final PCA of my certificate is not being considered by the question.
Nobody is present. Respondent, nobody is present. All right, none for the respondents. List on 8th. Let further notice be served. Yes, next.
I am for the respondent.
I am for the petition.
Led by Mr. Kaushik De, my lord.
20th April, your lordship directed to file a report as regards the status of the
Uh,
5th of May, they also took time, my lord, to file a report.
What does the report say?
My lord, already document already forwarded before the
CFSL.
forensic laboratory. My lord, on
It's awaiting.
15 April 2026, my lord.
It is awaiting. What can be done?
The similar order the past, my lord, your lordship, yesterday also passed an order directing the CFSL take steps.
একটু আগে যে অর্ডারটা দিলাম না
Item 30 minutes per
CFSL.
Respondent number
Same.
6 in my
Same. I have not mentioned the respondent number. Same. This report to be written with the records.
My lord, item number 28.
আচ্ছা, item 28 ওনার appearance-টা দিয়ে দেবেন তো for the respondent. Appearance-টা দিয়ে দেবেন.
Item 20.
নাম দেওয়া আছে, আপনি দেখে নেবেন.
Matter will appear on 10th of July.
Yes. And liberty has been given to mention in case it is done prior thereto. Both parties liberty.
Your Lordship, I am also there with Mr. Siddhartha Bhattacharya for all the respondents in this matter.
All right.
My lord, I have some preliminary objection on point of maintainability.
Yes.
My lord, kindly come to the cause title of this writ petition. The petitioner's address.
Petitioner's address?
Address, your lordship.
Jharkhand.
Your lordship.
What is the grievance?
No, and also see the affidavit, my lord.
Yes.
There is no similarity between the address given in the cause title and the address given in the affidavit.
The past address period is the permanent residential address.
Which one?
Nothing.
Jharkhand, Lord. Hazaribagh, Jharkhand, that is also written in his I-card, my Lord, may see at page 11A. The second address is not the quarter allotted to him. So this is, it is
118 battalion.
Yes, that is in Kolkata. And the third address, that is affidavit page, since the petitioner is 100% disabled, he cannot see. So he gave authorization letter to his son, Alok Kumar Jadhav. So this address is not his son's address, Alok Kumar Jadhav. Now his records all are maintained in Kolkata. He retired from Kolkata. He was posted in Kolkata. So cause of action arised in Kolkata.
What is the grievance?
That is because of Gracia grant did not pay to the petitioner because he was serving in Kashmir in the line of duty. He suffered bullet injuries and he is 100% disabled. Now, my lord, I took adjournment because in a similar matter I obtained order to place the order, my lord. Today I have the order.
Let me see.
At page 20, page 23 is not the notification. I am relying upon that notification.
Listen, the very first paragraph says that at that point of time, the petitioner was posted in Kashmir.
Yes.
Reliance has been placed in the Kashmir matter. Here, you are not so.
Yes, Kashmir.
No,
He was placed.
he was injured in Kashmir, but was
Same.
serving under the Hazaribagh battalion.
He was serving in Kashmir.
100?
118 battalion.
118.
Now 118 battalion, but that point of time in Kashmir was.
Yes.
Same circumstance.
Where is this government order number 10th July 1990?
Page 23.
23 is Kashmir or something, if I can correct.
That is the order.
Then why will the Kashmir order be applicable over here?
State of Kashmir is not a party here in my
Because the Honorable High Court specifically did not observe that page 24, paragraph B, that is applicable in my case. So in terms of paragraph number B, my lord, the Honorable Court directed the PS.
I just cannot follow. What is applicable to you?
Lord, the specific notification.
No, you file a report. Please come.
Your Lordship.
Lordship.
The prayer of the petitioner for grant of ex gratia payment can be decided only after hearing the stand of the respondents. Stop. The respondents are directed to file a report by way of affidavit disclosing its stand apropos the claim of the petitioner. Stop. Such report shall be prepared and circulated by 26th June. Release the matter on 6th July. Exception may be filed prior to the adjourned date.
Your Lordship.
Lordship, grateful.
Item number 76.
Milord, I am acting on behalf of the petitioners, Milord.
Yes.
This is a restoration application, Milord. And this application filed within time, Milord. Can we see page number 4, paragraph 2, Milord?
$276 monthly list restoration.
Yes, Milord.
কোথায় 276 কি মামলা দিলেন আপনি? তপনজ্যোতি পাল, এটা কি মামলা দিলেন? দেখুন তো ঠিক করে। What is the name of the petitioner?
Petition number 2, my lord. One is Ganga Sadhuka and is
আর করুন তো দেখি ওটা কবেকার দেখছি দেখুন তো
yes, my lord, I served.
Who did you serve? Who did you serve?
In past one, my lord.
Who
And
did,
Mr. Bhudap Chatterjee appeared before.
show me your service, the application. Application, please show. Can 4 you have served? Give a notice and come back. None for the respondents. Stop. Let the learned advocate for the respondents be intimated that the matter will appear in the list on 8th June. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 8th June. Let the respondents be put on notice.
Actually, in this matter, I appear for the respondent one, respondent bank one. On the last occasion, coordinate bench of this honorable court, my lord, directed us to file a report in the nature of supplementary affidavit, my lord. May I file, my lord? কপি তো দিয়েছে আপনার, এই তো কপি তো আপনাকে দিয়েছে। এই তো
Did you give a copy?
Yes, I have served.
You want to file an exception?
I'm for the. I did it.
You have already filed.
Yes.
Copy has not.
Affidavit in reply to report.
No, no, no. It is not that.
This is a supplementary report.
I think, my lord, they have not yet.
Supplementary report on affidavit filed by the bank in court today is taken on record.
Yes, my lord, I have got. This is a supplementary affidavit.
You want to file an exception?
I have filed one and not in the form of exception, but affidavit in reply to the report.
My lord,
How many reports are there?
My lord,
2 reports, my lord.
You filed 2 affidavits. Released on 8th June.
I have filed one affidavit.
It will be open for the petitioner to file exception to the report prior to the adjourned date.
My lord, record that I have filed my report, my lord.
Yes, that is kept on record.
My lord, I grateful, lord.
My lord, I don't know what to say.
June. 8.
280. Who are you representing? Canara Bank. The petitioner is not here. Let me see the. Yes.
But accommodate for after vacation.
Learned advocate for the bank seeks accommodation. Stop none for the petitioner. Released on 8th June.
Application for amendment of the petition. The earlier officer, my land was read and notice that he was not present, my lord.
Well, the amendment application I have been received, but they have again filed an application for amendment of the amendment by supplementary.
The court said that proposed amendment was not unchallenged by application.
But in which one I shall file opposition?
Supplementary affidavit to place the proposed amendment petition.
But I have not done.
That I have placed, not for an amendment of amendment.
But he has said, well, it has been written that there is a mistake in the amendment application. That's why, my lord.
No, that paragraph, my lord, the setting of the paragraph in the application, that is the supplementary affidavit, that clarified.
That's why.
Why do you want an amendment?
The amendment, my lord, in fact, one thing initially this when the petition was filed, my lord was pleased to entertain for certain reasons the violation of natural justice, all these things. Now, but after the when the matter was proceeded, when I was briefed, I found, my lord, that although the prayer of the appellate authority has been challenged, but there are one of the which also my replied that dismissal order of the primary authority is to be challenged, but the charge sheet and all other things, the defectiveness, my lord, was there, but specific readings were not there. In fact, for the specific readings had been, my lord, meant because at the time of argument, if I, my lord, proceed with the case, my lord, then it could be
well, after, my lord,
specific readings you have not made. Therefore, I cannot go into that because that reading, my lord, relate to the section itself. Because when the charge sheet was initiated, particular section has been mentioned, but that section said that major punishment to be imposed. Without referring a particular one of these sections.
So the pleadings, then the prayers has also.
Naturally, my lord, it is to be, my lord, it is jail.
Well, after receiving my opposition, my lord, they have, my lord, residual, my lord, the entire petition.
Actually, my lord, when I was big, my lord, I looked into it, my lord, I candid with you, my lord, that when I was big to argue at the final stage, then I found
a completely new case has been made out.
So after the defense is disclosed.
No, not defense, not looking to the defense.
No, he filed his opposition.
Yes, my lord, at the time of hearing.
That part is not looking at that, but this is the point, my lord, not, my lord, absolutely, my lord, devote the pleadings. Because I found, my lord, that I am challenging the order of the application of the disciplinary authority. There was the points were which has to be argued, but if I, my lord, proceed with the case, there are certain arguments which I may advance to your lordship with reference to the law. Your lordship could say that it is not, my lord, they not pleading.
You could not follow it up without the proper pleadings and the prayers. That is the reason you've come up. But in the meantime,
my lord, you should kindly come to the you should kindly come to the supplementary affidavit paragraph 4. But again, there is a mistake in the supplement application. They have been, narrated everything again. Well, which I shall file opposition, I don't know. But if a composite amendment application has been filed, then
you can see, the court directed me to file a supplementary affidavit.
That I understand. But what
proposing the
writ petition, there is a mistake.
Proposed amendment because in the application for the amendment, I have not done annexed. That is normally it is to be done. Then the court said it is to be placed so that it could be immediately it could be done.
So the last application amendment that you have filed was affirmed on 20th of January 2026.
That application for amendment is, my lord, and just I'm pointing out.
Application for amendment has been filed on. Yes, my lord. It has been served upon me on 11th of November 2025.
No, I see another one. An application for amendment of the writ petition 20th of January. But this doesn't contain a CAN number.
It is a CAN number. My lord, again, there are two applications. But it is a CAN number 1.
CAN 1 is separate.
CAN 1
application for
application for amendment.
Well, CAN 1, my lord, I have been served as an application amendment petition.
Lord, rightly said so that your proposed amendment application is not there. You can see the last 2 orders, 2-3 orders.
Did you serve this?
lord.
20th January 2026, is it served?
20th January 2026. Yes, my lord, yes.
You file your opposition to this.
I'm grateful to you. But then can may be disposed of, can 1.
No, that is the application for amendment.
Amendment. That is not the amendment. That is proposed amendment.
If you dispose that, that means the amendment gets allowed.
As you lord. So I shall file opposition to that.
Please come. An application for amendment of the writ petition has been filed. Stop. A supplementary affidavit affirmed on 20th January 2026, annexing copy of the writ petition along with the proposed amendment, is on record. Stop. It will be open for the respondents to file opposition to the supplementary affidavit.
I'm grateful to you.
By
For 2 weeks after vacation, my lord.
22nd June. Released on 6th July. Reply to the same may be filed prior to the adjourned date.
I know you those that pleading is the best thing to argue the case. Otherwise, any good case cannot also be pursued before lordship.
None for the parties. Released on 8th.
Let's item 284, 85. I appear for the petitioner. These are connected matters. The petitioners before lordships are the pensioners from Bose Institute and Autonomous.
What's your other side?
Let have served them. After mentioning, I've issued a notice upon them that the matter is running in the monthly list of before lordships.
Who is appearing till?
Mr. Shukanto Chakraborty is appearing for the Bose Institute and Mrs. Chandrai Alam is appearing for the Union of India.
None are present here. But none are present here.
Let's serve them, but let me just indicate this.
What?
Very short point is involved.
In the absence of the respondent.
It cannot be.
Then
any date, subject to your lordship's convenience. Very short point is. The pleadings are complete.
8th. None for the respondents. Released on 8th.
One innocuous prayer.
Further notice be served.
One innocuous prayer. There is some document which has come after pleadings are complete. May I have the liberty to bring those documents on record? It has got direct hearing.
This is a writ petition of 21. We are in 26. Now, if you add up new documents, then it will.
It's a change brief. I just found one thing. 300 pensioners. The case is 70% pension has under the 7 CPC disbursed, 30% withheld. Out of 300, only 118 pensioners have been deprived of the 100% benefit, whereas other 200 odd had been given the benefit. That document I wish to bring on record. It's subject to lordships for convenience.
I don't know. And when did this document that you are speaking of got generated?
After 2023. Then the change brief I have recently.
I understand. Then why do you want to put it on record? You keep it with you. If required, we'll see.
My loss.
Again, then if you file supplementary, they'll go for an opposition or something and it will get delayed.
Can it be on 9th, your lordship?
No, it will be on 8th because the combined list will be published. That is the reason.
It's a hearing matter. It's a hearing matter.
It's a hearing matter. It will.
So grateful.
It's an adjourned motion.
So grateful.
84, 85. I beg to appear for the petitioner, my lord. Here, my lord. My lord, are the employees of regulated market committee.
The state is not here.
My lord,
market committee is also not here.
I believe, my lord, panel of market committee has not changed, my lord. I don't know.
Where is the market committee council? Nobody is there. Prior to the vacation urgent motions, nobody is interested.
My lord, the difficulty is, my lord, the petitioners are the poor employees are getting a minimum remuneration. What has happened, my lord?
No, what can the court do? Bring your other side.
My lord, may I file my exception to a report?
Yes, yes, certainly. Exception by the petitioner to the report filed by
Filed by the, my lord, respondent number 2 and 3.
state.
No, my lord, board.
Acha. By the respondent numbers 2 and 3 in court today be taken on record. Has copy been served?
Yes, my lord, I think it has been served.
Released on 8th. None. না তার আগে লিখবেন none for the respondents released on 8th. Let further notice be served upon the non-appearing respondents.
Not copy served. 22, my lord, 2011, 220 appointments were given. Previously, my lord, pursuant to an order of this court, my lord, an inquiry was conducted.
Come next day, please. Yes, next.
My lord, may I please your lordship, my lord, I appear for the respondent. I don't think the petitioner will appear.
Why?
The reason is after seeing the affidavit in opposition, they have stopped appearing. They have tempered the division
Anyway.
bench order.
None for the petitioner. The respondent is represented. Released on 8th.
My lord, may I just say this thing, my lord, I am seeking a dismissal not on the ground only for non-appearance, but on the ground they have tempered the division bench order.
The matter has been posted on the 8th of June.
Very well, my lord, I'll come back and renew my prayer on that day.
Yes, next. আর ডেকে কাজ নেই, কেউ আসছে না এখন তো।
Item number 1.
I beg to appear for the respondents, my lord.
Yes.
My lord, this application, my lord, originates from a proceeding of court martial, my lord, under the Navy Act, my lord. Now, there are certain issues, my lord, which transpired during the court martial. Number one, my lord, time and again we had been requesting to provide the copies of the statement of the witnesses that has been recorded. That's the examination in chief and the cross-examination, my lord. That was denied. Well, surprisingly, what the procedure was adopted in the court martial was a witness was called, statement was recorded, that was taken out in shorthand. Witness goes, my lord. It is not typed in the presence of the witness, nor in the presence of the accused or his defense counsel, nor the statement after typing is read over to the witness, nor the signature of the witness is obtained on the statement. So these are the procedural aspect. And secondly, the statement is also not provided in spite of repeated requests, my lord. My lord is aware, my lord, fair trial, accused is entitled for all these, my lord, because if it is not recorded correctly, the witness will come up and say that it is not recorded correctly because it has to be read over, his signature or her signature is to be obtained, my lord. This is not done. Now, my lord, secondly, my lord, they proceed with the court martial, my lord, and even, my lord, if certain things are not recorded I have a right even to file an application to recall the witness for further cross-examination on certain aspect. Proceeding goes on without providing all these things, my lord, and it is posted for final argument, my lord.
But then why can you not raise all these issues before the Armed Forces Tribunal, which is functioning?
My lord. No, my lord. Firstly, my lord, when we have no issues raising the issue before the Armed Forces Tribunal. My lord is aware that there is scarcity of members in all the tribunals in view of the Madras High Court judgment, my lord, where the appointments are an issue, my lord. Now, the Armed Forces Tribunal is running short of members. It is not functioning, my lord, on regular intervals. On the date, my lord, when this application was filed, the setting of the Armed Forces Tribunal Eastern Zone at Calcutta was not functioning. It sat for a period of 3 days, my lord, at Cuttack. At Cuttack, the Eastern Zone, basically the Cuttack bench sat down there and some matters of Calcutta was taken up at Cuttack. My lord, that was not on the date of filing of the, my lords would appreciate that we don't know when that notification will come, when a bench would assemble at a different location, filing it from Andamans, and there are constitutional issues. Now they have raised an issue, my lord. They have taken refuge under the provisions of Section 129 of the Armed Forces Tribunals Act, my lord. My lords may kindly see of the Navy Act, my lord, of the Navy Act. Very interestingly, my lord, there was a provision, there's a regulation, my lord, because my prayer that challenging the virus of the rules is there. If my lords may kindly come to the affidavit in reply, what I have filed, my lord. Kindly come to, and it is very difficult to participate in a proceeding which is conducted by the naval authorities, because with due respect to the members who conduct the court martial, none of them have a legal background. They're all commanding officers and of various ranks. They're all basically technical people having basically no experience and no knowledge of law. My lord, may kindly come to the affidavit in reply which was filed by me. I think it must be there, my lord, because it was filed in the registry.
Yes, it's there.
My lord, may kindly come to page 12, my lord, of my reply.
Yes.
My lord, but see, it's not, because even these notifications are not available, my lord, in the public domain, my lord. If my lord would see 189, I have put the typed copy on the next page, my lord. One page on the next page. There's some pagination mistake. The last page. My lord, may kindly come to the last page, my lord.
Yes.
Regulation
Supply
189
of
regarding
copies?
supply of copies of proceedings deleted by SRO number 2 dated 23rd December 78 public. Supply of copies of proceedings dated 23rd December 1978 published in the Gazette notification, my lord, under the regulation where the accused was entitled for a copy of it. Now the question would be whether such deletion is within the parameters of the constitutional provisions, whether this deprives an accused of a fair opportunity of a trial or not, my lord. Because it is unheard, my lord, that the statement of witnesses is being recorded in shorthand. The witness goes, it is typed later on, it is not read over to the witness, the signature is not obtained, copies are not supplied, not even given to me, and I'm asked to do a final argument on the matter. Unheard of, unheard of. This needs, my lord, to be decided, my lord. This is a very important constitutional issue, my lord. It strikes at the root of a fair trial, my lord. Now, I'll show one more thing, my lord, very interesting. My lord, may kindly come to page 89 of my stay application, my lord. '89 of my stay application. Well, during the during the midst 89 of the stay application, my lord.
Yes.
Might be a slightly thick one. My lord, got it, my lord?
Yes, yes.
My lord, when the court martial is going on, my lord, they produced a phone, my lord. In the midst of it, a phone is produced and an application is filed for forensic examination of that particular phone. Two things, my lord. First, kindly see who files that application. The prosecutor, not the investigating officer. My lord is well aware of Jessica Lal's judgment. The Honorable Supreme Court has laid down what is the role of a public prosecutor is neither here nor there. He has to act independently. He can't move this application. It has to be by the investigating officer. He moves this application. We object to it on the next page. It is said there is no seizure, no panchanama. From somewhere something has happened. This is they say it is seized about 2 years back. Where it was kept, nothing. No decision on this. Now, if I want to challenge, I raise an objection to this particular procedure adopted by the tribunal. Now, if I want to challenge, I need the daily order sheet. Unless I get that particular order which I objected to at page 90 to this application of the prosecutor, what decision the court martial has taken, how can I, my lord, challenge it before even the tribunal? They bring something, no seizure, no panchnama, from where it has come, in whose custody it was there, whether it was tampered or not, who handled it, nothing. Apart from that, there are various issues, my lord. And a person who is not even competent to investigate the matter, my lord, has carried out the investigation in this case. My lord, I will also show, my lord, just one more small thing. In my affidavit in reply, my lord, kindly come to page 10 of my affidavit in reply. Sorry.
Yes.
My lord, I'm a sailor, my lord. I'm a sailor in the Navy. As far as I know, my lord, in Andamans, my lord, there are different units, my lord, under the Navy. One is INS Dhanvantari, my lord. That's the hospital unit of it. Then there is one INS Jarwa. There is one INS Utkurosh. As far as I know, my lord, these are the three, one at Port Blair and there are some units, one at Diglipur and one at Campbell Bay. So, my lord, what happens, my lord, if there is an allegation against an officer, my lord? Say, for example, I'm attached to a particular unit. So, in order to have a fair investigation, that officer is attached to a different unit, my lord. Because if a person of an officer rank possibly might be in a position to influence the investigation or hamper the investigation. The rule says, my lord, only an officer can be attached from one unit to another unit, my lord. I'm a sailor. There is no provision under the law where a sailor can be attached from one unit to another unit. My lord, may I kindly come before I take my lords, may kindly keep page 10 of the reply in one side and kindly come to page 35 of the stay application. These two documents, my lord, needs to be seen simultaneously, my lord.
Listen,
Page
the first
35.
thing, the court is thinking
My
whether
lord.
to enter into the merits of the matter or not, because piecemeal hearing will not inure to anybody's benefit, right?
These are
The
procedures.
preliminary objection has been raised by
kindly
the,
give.
Sorry, ma'am.
a preliminary
what I
objection
would-
has been raised with regard to the maintainability.
My lord, may decide that, my lord, on the particular day, when the cause of action arose, my lord, because the proceeding is going on day-to-day basis, my lord, on day-to-day basis, depriving me of the fair opportunity of trial, investigating by an incompetent officer, not permitted under the Act, my lord. I can't wait for the Armed Force Tribunal to assemble and then move an application. Even today, there is no Armed Force sitting on the tribunal. Possibly they are sitting tomorrow. Please, you will have your turn, Mr. Balan. It will be sitting possibly from tomorrow for 3 days, where the one member possibly from Delhi is coming and joining 3 or 4 days, something like that. It's not a permanent bench.
The tribunal is functioning since yesterday and it will function till tomorrow, 18th, 19th and 20th.
Yes. I think something like that. 3 days they have said so in their affidavit. If my lord may kindly see the opposition that they have filed. Somebody is
And
sitting.
where is the tribunal assembling? Somewhere in Kolkata or in Port Blair?
Kolkata.
No. This time in Kolkata, my lord. This time for 3 days.
But if this is the regular system, then you have to follow it. Just like when the circuit bench is not available, you approach the principal bench and then the matter is transferred to the circuit bench. It is the same thing.
No. Now, this is not the same thing, my lord. This is on account of paucity of members being appointed by the central government. Now, on account, with due respect, my lord, if the government is not able to appoint the members to the tribunal, which is it's a statutory body, a litigant is entitled to access to justice on a regular basis, my lord.
And that is the reason the court entertained your matter on the last occasion, because the tribunal was not functioning on that day. But then, admittedly, today the tribunal is sitting, right? Till tomorrow, right? Now, what is the interim relief that you are seeking?
My lord, it has only first thing, my lord, it has to be decided whether the constitutional issue, whether this deletion of regulation 189 is constitutional or not. So that needs to be that, my lord. Even the tribunal is not in a position to decide, my lord, that's a constitutional issue, my lord.
This deletion took place long back.
Long back.
Right. Now,
and I was not accused at that material point of time.
Maybe. But then this legal provision is accepted and it is there for quite some time. What is the immediate threat that you are facing now? Papers are not, what you said is that you are not getting the copy of the evidence that you have given.
They have now, it's at a stage, because I am agitating this issue, my lord, for the past 3 months, my lord. And they have proceeded with the matter, and then they at the verge of pronouncement of the judgment. If the judgment is pronounced, my lord, without affording me a fair opportunity of trial, my lord, I would definitely be prejudiced, my lord. These things.
Let me understand from Mr. Balan. Tell me, do you all provide copy of the evidences?
My lord,
what is the legal provision in the Navy Act?
My lord, I pray that my officer, naval officer having...
Yes.
Navy Act,
my lords, if I may submit, my lords.
Yes, please.
My lords, before a naval officer is present there, my lords, she will submit all the laws, my lords.
Yes.
Navy Act and regulations are there, my lords.
Yes, it's there in front of me.
Ma'am, my lords, first and foremost, I would like to draw your attention to Section 4 of the Navy Act, my lords.
Yes.
Section 4 of the Navy Act, it says fundamental rights to apply to persons subject to naval law with modifications.
Right.
The rights conferred by Part 3 of the Constitution in their application to persons subject to naval law shall be restricted or abrogated to the extent provided in this Act, my lords. So first and foremost, ma'am, my lords, the Act itself falls under the purview of Article 33. It's a law made by the Parliament wherein the fundamental rights have been abrogated, my lords. Now, my lords, along with this, I would request my lords to come to Section 122 of the Navy Act, my lords. Now, Section 122 speaks about of the Navy Act, my lords. Navy Act.
Yes.
It speaks about adjournment, my lords. It says a court martial may, if it appears to the court that an adjournment is desirable, be adjourned accordingly, but except where such an adjournment is ordered, shall sit from day to day, with the exception of Sundays, until the trial is concluded, unless prevented from doing so by stress of weather or unavoidable accident. So the law is very clear that it's a speediest trial available, wherein the court has to sit on day-to-day basis. Now, my lords, I would draw your attention to regulations, my lords. In this, if we come to regulation, that is how the proceedings are held, my lords.
All right.
My lords, I'll come to regulation 187, my lords.
Regulation
187, my lord.
187.
My lords, it's
Section or regulation?
Regulation, my lords. Of the regulations for the Navy Part 2, that is the Naval Miscellaneous Discipline and Miscellaneous Regulation 1965, my lords.
Period of sittings.
Yes, my lord. It says ordinarily court martial shall sit 5 hours a day, and its sitting shall not be protracted without specific reasons. Now, along with this, my lords, I will come to Regulation 191. It casts responsibility of trial judge advocate for preparing minutes. Not as learned counsel for the petitioner said that there is no legal person here. That is a completely a wrong statement, my lords. This is a jury trial wherein the 5 members of the Navy sit. They are duly assisted by an officer of the Judge Advocate General's Department, who is completely a legally qualified person, my lord. So it is his responsibility. It says the trial judge advocate shall be responsible for ensuring that the minutes are duly recorded and prepared. Now, sub-regulation 2, my lord. The transcript made by shorthand writer shall be made under the directions of the trial judge advocate, and both the shorthand writer and the trial judge advocate shall certify that the transcript is a faithful record of the proceedings. So, my lords, once the proceedings are over, it is certified by the stenographer as well as the trial judge advocate, so to maintain the fairness of the recording, my lords. Now, my lords, as regards the witnesses, my lords, how they are examined, that is in regulation 179, my lords.
Tell me one thing, 187, the court martial sits 5 hours a day. But
Yes,
is it
my lord.
continuous?
No, my lords. We sit for 1.5 hours, then we take a break. Then again we sit, my lords. So during this, the stenographers are recording, my lords. So totally.
All right, that is all right. But then is it 5 days a week, 7 days a week?
No, 6 days a week, my lords. 6 days a week, and only exception is Sunday, my lords, as we read in section 122 of the Navy Act.
Right. So
Yes.
6 days a week continuous. Is it
Yes, ma'am.
continuous?
Yes, my lord. Yes, my lord.
It is.
It is, my lord. So, my lord, that
All
is
right.
why, my lords, the stenographers are recording everything in shorthand. 5 hours of recording per day cannot be transcribed immediately in one day, my lords. So that is the practical. That is why.
So it's an admission. So it's an
Wait,
admission, my lord,
Mr.
can be took.
Please,
My
Mr.
lord,
Tabriz, let him make his point.
We haven't interjected when he was speaking. I request learned counsel not to interfere in between.
Don't address me. Don't
Mr.
address me.
Tabriz, please wait. Yes.
My lords, so now coming to my lords, section 120. With this background, I will come to section 129, my lords, of the Navy Act.
Section 129, yes.
Lord, it says right of accused to copy of proceedings and sentence. Every person tried by a court martial and convicted shall be entitled on demand to a copy of the proceedings and sentence of such court martial free of cost, but no such demand shall be allowed after the lapse of 1 year from the date of final decision of the court, my lord. My lords, I would like to highlight one thing. In every court martial, my lords, the accused is entitled for a defense counsel of his own choice, my lords, and invariably, the defense counsel who is aware about the court martials, he comes along with an assistant having the knowledge that day-to-day proceedings cannot be given to him. My lords, even in this case, there are 2 wakalatnamas filed on behalf of the accused, and the second assistant counsel keeps on noting the evidence, my lords, their points jotting down. The witnesses have been extensively cross-examined for more than 2 days, my lords, the relevant witnesses. So now coming in front of this court and saying, I have not been given opportunity, I am not able to understand, my lords. And finally, my lords, on 15th of May, defense counsel has finished his summing up, my lords.
Defense counsel has?
Finished his summing up, my lords, his arguments, my lords.
Submitted arguments?
Yes, my lords.
Under protest.
He has submitted 42 pages arguments, my lords.
All right. Now tell me, the shorthand that has been taken, how soon are those transcribed and typed?
My lords, as soon as the trial judge advocate gets time, he keeps on transcribing them, my lords. But it cannot happen day to day. Sometimes the trial judge advocate sits even on Sundays, my lords, so that he doesn't lose track of the things.
All right. So can these transcripts be provided prior to the arguments? Are physical arguments being taken?
Yes,
or just submission of written argument?
Physical
arguments are taken.
Yes,
all right. So is there a possibility that the transcribed copies of the recordings can be provided prior to the oral arguments taking place?
My lords, they are already, my lords, I will highlight another thing, my lord.
Yes.
The defense counsel has submitted an application on 16th of May stating that that has been placed before review, my lords.
Yes, he sought for those documents.
No, my lords, there is one more, my lords. There is one more application on 16th of May.
Our officer is there.
Our officer has might have provided that document, my lord.
In court.
In court, my lord. In today, my lord. Today she might have submitted, my lords.
Today it has been submitted. What?
My lords, there is along with the rules, there is one application, my lords, wherein the defense counsel says that I have completed my summing up in accordance with section 111, subsection 9 on 15th May 26. I wish to withdraw from this honorable court as I have to attend a court martial at HQWNC, Mumbai on 18th May 26. He says that I have completed everything from my side and I may be permitted to withdraw, for which the accused consents. My lords, and as regards, my lords, day-to-day proceedings, there is an honorable Supreme Court judgment, my lords, who has considered this judgment in the case of Flight Lieutenant G.S. Bajwa. It's an Air Force court martial, my lords. In this, the Supreme Court has already held that non-provisioning of day-to-day proceedings will not affect the rights of the accused, my lords. My lords, if I may draw my lord's attention to the head note echo and the paragraph 40 of the judgment, my lords.
Citation, please. Citation, please.
Citation is 2003 Part 9.
Mr. Balan, cite.
2003 Part 9 Supreme Court cases 630. Lord, it says,
Sir, we are not going into the merits of the matter at this stage, right? What the court is concerned and what the court can understand from the petitioner's submission is that he wants the copy of the recording so that he can prepare himself for the argument. This is the only thing. And then whatever the argument is, it will be there before you. This court will not enter into it at this stage. There is hardly any scope.
My lord, the judgment which I am quoting, my lords, in that the Supreme Court has said he can be given an inspection of the proceedings
All
and
right.
not the copies, my lords. He can have the inspection, my lords.
All right.
He can
When
have the
can the,
inspection.
is the recordings transcribed by now?
Yes, my lords. They are transfer. I have confirmed, my lords. They have been transcribed, my lords.
All right. So why don't you provide inspection? Mr. Tabriz, you can take inspection of these. And you take down
My lord,
notes and everything. You have a defense counsel who had already taken notes.
My lord, kindly appreciate, my lord, which the submissions which had fallen from the other side. A procedure unheard of that you take shorthand. Shorthand is permissible. Shorthand is permissible under the regulation, no doubt about it, no quarrel about it. But can the shorthand be transcribed at a subsequent date and not read over to the witness, not obtain their signature? What would be the legal sanctity of those statements, my lord?
All right, that will be later on. Right now, you can take inspection and see, and then make your arguments over there.
My lord, what I would request, subject to my lord's acceptance, my lord, I may be permitted inspection, my lord. Let this, I don't know whether they'll allow me inspection, a fair inspection. Me, in the sense, the other defense counsel who's coming from Mumbai in this particular case, my lord. Let this matter be transferred over, my lord, to the circuit bench at Port Blair. In the meantime, my lord, let them be called upon to give me inspection. So if they provide me a fair inspection, my lord, I'll make my submissions and the matter can be disposed of, my lord.
When is the circuit bench at Port Blair sitting?
My lords.
My lord, 8th of June, my lord.
June. All right.
My lord, we have.
And I do not know in the meantime if the arguments are over before the armed force, not the tribunal, before the court martial.
My lord, may kindly come to the reply what I have filed, my lord. Kindly come to one page. The other side is showing something, not showing something. Kindly come to page 11, my lord.
No, I do not want to go into it. I will not go into it at all because
no, I specifically
it becomes very difficult.
I specifically say on 16th that during the course of the summoning on 15th May, the undersigned was constrained by non-availability of the recorded proceedings and deposition of witness examined before the court in the absence of authenticated copies of proceedings. The defense counsel.
My lords, there is no provision for providing copies.
Please.
And this has already been settled by Honorable Supreme Court, my lord.
Where is your application? What are the documents that you require inspection of?
My lord, the statement of all witnesses who have been examined in chief and cross-examined, my lord, whether the recording was correct or not. I might have taken down something, noted down something, but whether the recording in the proceeding, the transcription which is there, my lord, this will ultimately affect me, my lord, because if I don't agitate this, if an adverse order is passed, I cannot agitate it before the Armed Forces Tribunal or before the Honorable High Court or before the Supreme Court. The authenticity of the recording, my lord, which is the foundation of the trial, needs to be seen, my lord.
Listen, what has been read out is that it is to be signed by the judge concerned, right?
My
How
lord,
can you disbelieve the judge?
Yes, my lord.
Well, my lord, it doesn't, but it doesn't say, my lord. It doesn't say, it has to be said. It doesn't say that you do it after a week or you don't do it immediately. 191, possibly.
The regulation 191 that has been read out, it clearly mentions that the trial judge advocate shall be responsible for ensuring that the minutes are duly recorded and prepared.
Duly recorded and prepared. What do we infer?
The transcript made by the shorthand writer shall be made under the directions of the trial judge advocate. And both the shorthand writer and the trial judge advocate shall certify that the transcript is a faithful recording of the proceedings. How can you disbelieve?
My lord, does this permit that they can do it at their own whims and fancies after 1 week or 10 days and manipulate it?
No, it is. You cannot say that way.
My lords,
they have admitted that they do it on the next day. They do it. Please.
My lord, this aspect has already been considered by Supreme Court. Similar objection was raised in that case, my lords, and Supreme Court has heavily come down on the party, saying that mere allegation will not suffice without any specificities, my lords.
The dictations that we give in court here in the High Court,
There
they
in
are not
Bajwa's case,
necessarily,
in
Mr.
Bajwa's case,
Tabrez, the
My lord.
dictations that we give in court, right,
My lord.
in the High Court, they are not necessarily transcribed on the same day. It comes on the next day or even a day after, right? So
my lord,
it
the
is the
orders are
judge.
different. My lord, the orders are different. Dictating the orders are different, my lord, subject and recording of the statement of witnesses are different, my lord. I will with due respect, my lord, with due respect, I will differ on this, my lord.
My lords, one small aspect, my lords, I will draw attention to Regulation 179, my lords. I will clear the apprehension of the Defence Counsel, my lords.
Yes.
The Counsel for the Petitioner, my lords. Regulation 179, my lords.
Yes, please.
Regulation 179. My lord, it says mode of questioning of witnesses, my lords.
Yes.
Here, sub-regulation 2 says the evidence of a witness as taken down shall be read to him if he so requests before he leaves the court. My lords, in the open court, whenever any question is asked and if the witness is not understanding, the question will be repeated to him. The answer of that question will be repeated to him, my lords. Then, and shall, if necessary, be corrected, and if makes any explanation or correction, the prosecutor and the defense counsel may respectively examine him regarding the same. Now, I will come to sub-regulation 3. Sub-regulation 3 says, if the witness denies the correctness of any part of the evidence, when the same is read over to him, the trial judge advocate may, instead of correcting the evidence, record the objection made by the witness, my lords. My lords,
So there are checks and balances as to how witnesses recordings.
My lords, the entire procedure is a foolproof procedure, my lords. These are court martials which are being held since 1957, my lords. So merely making that the defense authorities will manipulate the documents or manipulate the evidences, that too in a trial where the charge is under section 388, my lords, for extortion, my lords, by putting someone in fear of accusation of a rape, my lords.
Please come.
I have, as of now, I have not raised any acquisition because until I see.
Petitioner is facing a court-martial stop. He alleges that the recordings of the examination in chief and cross have not been provided to him despite request being made.
Well, repeated request.
Repeated requests being made. Stop. The respondent submits, relies on the Navy, bracket open, discipline and miscellaneous provisions, bracket close, regulations, 1965. Particularly, regulations 179, 187 and 191. Stop. It has been submitted that the inspection of the evidences may be provided to the petitioner if sought for. Stop paragraph. Be it recorded that the Armed Force Tribunal is functioning on and from 18th May till 20th May 2026. Stop.
That's tomorrow.
On the day the writ petition was filed, the Armed Force Tribunal was not in session. Stop paragraph. The petitioner has raised certain issues with regard to vires of certain provisions of the Navy Act. Stop paragraph. As an interim measure, prior to that, it has been brought to the notice of the court that written argument has already been prepared by the petitioner and submitted before the court-martial.
Under protest, my lord.
There was no protest.
According to the petitioner, the same was filed under protest.
My lords, there was no protest, my lords.
Which
it's on record.
My lords, they finished their
paragraph
15th and subsequently.
Be that as it may, as the respondents have expressed that inspection of the A recording of the evidences may be that the recording of the evidences may be permitted to be inspected by the petitioner, comma, accordingly, the petitioner is directed to approach the authority with his prayer. Stop. If a prayer for inspection is made, comma, the same shall be considered by the authority in accordance with the provisions of law at the earliest. Stop. Respondent authority, please say when can the hearing be fixed?
My lords, they can inspect it tomorrow, my lords.
Tomorrow itself?
Yes, my lords. Yes, my lords.
Without an application being made?
We concur for his inspection, my lords. If you want, my lords, because
when is the next date for hearing?
My lords,
no date has been given.
No date, my lords, it is on 20th. The date has been tentatively fixed 20th. My lords.
No date has been given.
It has been given, my lords.
20th means tomorrow?
Tomorrow, my lords. Yes, my lords.
Can the officer show any communication from where the date has been given, my lord? Incorrect submission before the court.
Communicated to the parties or dates are?
It is
communicated to the accused, my lords. The counsel for the petitioner may confirm it from the accused.
Achha, do one thing.
My lord, just one thing, my lord.
It has been submitted by the officer.
My lord, just one thing, my lord. The defense counsel, my lord, I'm not representing him in the court martial, my lord, because he's an ex-Navy having with a background. He comes from Mumbai, my lord. On 16th, my lord, after this proceedings had reached this stage, my lord, he had gone back to Mumbai. So he has to come back from Mumbai, my lord.
My lord, inspection can be done by
No, he has given a letter that has been placed before this court, which says that he will file a mitigating statement or something of that sort.
Yes, my lord. Yes, my lord. Absolutely, my lord.
But if inspection is given, my lord, he'll come back again because he was forced to complete his argument, my lord. So he made his submissions and he has left.
My lord,
He can't wait.
The
Mr.
defense
Balan, please
counsel
tell your
has,
client not to
listen,
say
the defense counsel has specifically mentioned that the accused has no objection to my withdrawal. That means it is no objection was raised by the petitioner over there.
Yes, my
with
lord.
regard
My
to
lord,
the withdrawal of
my lord, kindly come to the other application, page 11 of the reply, my lord. 2 applications were filed on that day.
My lords, on the same day, my
He
lord.
can't stay. What, my lord? What is this officer, my lord? He just keeps
the last line.
speaking in between.
What is the last line? No, you strike that off.
If they can behave in this
record that
court, what they would be doing in the court martial?
Please record that it has been brought to the notice of the court that the date of hearing before the court martial is 20th May 2026 and the same has been intimated to the petitioner who is an accused in the court martial proceeding. Stop paragraph. It has also been submitted that inspection of the proceeding may be provided to the petitioner tomorrow itself, that is 20th May 2026. Stop. It will be a paragraph. It will be open for the petitioner to take inspection of the documents tomorrow. That is 20th May.
It may not be possible. The
2026.
defense counsel has to come from Mumbai, my lord.
No, my lord.
You engage
the
somebody.
defense counsel has to come from
I
Mumbai,
do
my
not
lord.
know.
Yeah.
My lord, this letter was given prior to these proceedings. So how did that advocate from Mumbai, how would he know that this order will be passed for inspection? Because earlier they have denied.
16th May
but
this
it has
letter
been
was
already-
given.
Today we are on 19th. So how he would know that this order will be passed?
You don't have somebody from the
even this would
islands over there. He has to come all the way from
My lord,
Mumbai.
they have my lord, they have a totally different procedure, my lord. Normally, we don't appear before the court
Yes.
martial. So
No, but the
mostly the
inspection of documents.
ex-Navy with law background. My lord,
The
a person
inspection
who
of
has been
documents
conducting
also
the
has to
trial,
be done by him.
it would be, my lord, it would be because he knows, my lord. it is the learned defense counsel, my lord. He knows what was stated in the court martial and what has been recorded. If, say, for example, I go tomorrow, I don't know what was stated by the witness, so I can't raise an objection.
Respondent of officer, will you please say what can be done if the counsel has to come all the way from Mumbai?
My lords, the accused was present throughout the trial, my lords. He can very well ascertain what has been stated in the court and what has been recorded, my lords. If he has any objection, he can very well raise that objection.
But then, if he requires the assistance of the defense counsel, cannot one day be given?
Can be given, my lords. But
when can the next day be? Then I can record it in the order itself.
As I am aware, my lords, the defense counsel was defending him. He is engaged in another court martial at Mumbai, my lords. So he may not be able to come, my lords. And my lords, at this juncture, the only thing which is left is for the court to retire for findings, my lords.
Yes.
Because arguments have already been and my lords, 5 officers of the Navy are being held only for this purpose, my lords. And as per 122, we are required to sit on day-to-day basis, my lords.
Even CRPC says one day-to-day basis.
CRPC
this is a specified act, so you have to go according to this act.
Yes, my lord.
Well, my lord, I just got instructions, my lord.
Tell me one thing, 1 minute. Tell officer, will you please instruct as to whether this person, the sailor, is in suspension or something of that sort?
No,
he's on duty.
No custody, my lords. Not at all, my lords. He is roaming free, my lords.
He is roaming free.
Yes, my lords. After commission of an offence under 388, my lords, of IPC.
All right. So, in that case, at best, what the court can do is, see, today is Tuesday and tomorrow, Wednesday is the date fixed. At least till Friday, I can give, not more than that.
My lord, I just got a message from him. I just asked him through WhatsApp, my lord, when he's getting free.
Yes.
So he's getting free from the other court martial, my lord, in Mumbai by this weekend. So we can have it by the next weekend, my lord.
Well, how can they wait for so long? 5 of the Navy officers are there.
5 naval officers, commanding of the
it is not, my lord, it is not that they're sitting there. If the court martial is not there, they will be discharging their duties.
I do not know exactly how the court martial proceeding goes on. So it's something very new to me.
My lord,
and to you also, Mr. Tabrez. That is the reason you are not going there to inspect the documents.
My lord,
possibly,
and that is the reason Mr. Balan is also quiet.
My lord.
If we go, possibly the situation may turn out to be something else, the manner in which the proceeding is going on.
Right, yes. So it's better left to them. It is their job. Let them do it. Then I do not know how you can do it. By Friday,
which time, my lord? Which time? I will ensure either the gentleman comes because they
a small submission, my lords. Even the trial judge advocate
2 of them
has been deputed from Delhi, my lords. From the naval headquarters, my lords.
I don't know what to do because you say the counsel is not available. And somebody has come all the way from Delhi only for the court martial proceeding.
Yes, my lord.
And then I give you time till Friday. Mr. Tabrez, please make arrangements.
My lord, till Friday, at least till Monday, till Friday, he's engaged in the other court martial, my lord.
Again, the weekend will come.
My lord.
Monday,
the
my lord.
will be intervening.
So in the weekend, he will travel down here and Monday he will appear, my lord.
My lords, with the assistance of any counsel, the accused can inspect, my lords. He can get assistance of any of the counsels, my lords.
Lord,
because
he is a sailor.
He is the accused.
He is a sailor. He doesn't know what the witnesses stated and what was recorded. What was stated and what was recorded, the best person would be the defense counsel who had conducted the trial.
My lords, the accused would be
I could have gone.
What did I say? Tomorrow, learned counsel for the petitioner submits that the defense counsel has already intimated the president of the court martial that he would be engaged in another trial in a court martial at Mumbai on 18th of May. Stop paragraph. Prayer has been made by the learned advocate for the petitioner to give some more time so that the learned defense counsel can attend the inspection. Stop paragraph. The court grants time till 22nd May 2026 for conducting the inspection. Stop. Let the after the inspection is conducted, the court martial proceeding shall continue strictly in accordance with law. Stop. The writ petition is made returnable before the circuit bench on 8th June 2026. Madam, you can take
My
these.
lord, interim order to continue.
My lord,
interim order to continue.
What is the interim order?
Not to pronounce the judgment.
Not to pronounce the judgment.
Because after
My lord.
inspection, we may give another notes of argument.
My lords, they can access that right, my lords, if they want to give additional arguments after inspection,
Yes.
my lord.
Yes.
But
I
these
can
things cannot be stayed, my lords, because the only thing which is left is
I can even file an application for recalling the witness also.
Yes.
No,
I
but
can-
then see, why are you anticipating that they will not give you the permission to recall your witness or to file additional evidence or witness or whatever? You
Right,
go-
my lord, the manner in which the proceeding has proceeded gives all apprehension for those apprehensions.
My lords, the court martial started in
if
on
they move
18th
on day-to-day
February,
basis, if they move on day-to-day basis, you say that they are moving at in lightning speed. If they slow down, you say that they are not working. Where will these people go? They have to maintain a balance. The law
My
says
lord-
that it has to go on day-to-day basis, and this is
My
what
lord-
they are doing.
Well, it doesn't even CRPC says it has to be day to day. That doesn't mean that they will bypass all the.
No question of bypassing. In case there is any difficulty, the writ petition is returnable on the 8th. You can file subsequent applications. Take these two back.
My lord, let the interim order continue, my lord. My lord, let the interim order continue. Not to pronounce the judgment. This was granted by this.
It will be open for the petitioner to apply before the court for further relief if required.
Obliged, my lord.
Obliged, my lords. Obliged, my lord.
All other points are kept open, my lord. All other points are
The
kept
writ is pending. No point has been decided at all.
open.
It is
My
only an
lord.
interim measure granting you time for inspection.
My lord.
Obliged, my lord.
All right.
Obliged,
My lord, 22nd is a Friday, my lord. My lord,
Yes, that
22nd
is
is a
the
Friday.
reason
My
I have kept it only till Friday. I am not giving you the weekend.
lord, can you keep it on 25th, my lord?
No,
Because he
no.
may not.
No. Today is the date given by the council is 18th, and 22nd till 22nd is 1 week time. Let him make
My lord,
arrangements.
my lord, then kindly record my submission that the defense counsel is not in a position to come till by Friday, my lord.
There are two councils. You said just now. You make arrangements.
No, there are not two councils.
There are
All right, you make necessary arrangements. Call the next matter, please.
Obliged, my lord.
No.
Obliged.
Obliged, my lord.
Yes. No.
Lordship, I am for CSTC led by Mr. Bihani. Lordship, due to some medical emergency, Mr. Bihani left the court today. Lordship, I am praying for only not today.
Not today. After vacation is better.
16th.
As you
Why 16th?
16th June.
Why 16th? 18th, 8th of June, the combined list will be published. Let it remain in the list.
18th June.
You make prayer for adjournment on that day. We will see. Let it remain in the combined list. You make adjournment prayer. I'll see. By consent of the parties, list the matter on 8th June.
Grateful.
No Passover. After vacation.
For the respondent.
For the scenario.
Yes, is the state required?
The state is also party member because he is appealing for the undertaking below is undertaking of the state. So here below the point below.
Is the state required or not? If state is required, then it will be adjourned.
Beseech your Lord, pray for me. Lord, I Lord, beseech your Lord to allow me to file a supplementary.
Why?
Why, Lord? Lord, the issue was that Lord, I am a Lord contractual employee. Lord, after I made a conference with my client, Lord, Lord, that is a junior group. I came to learn that virtually, Lord, I will prove either contemporary documents which is with me. They from their records, Lord, it Lord shows that he was a permanent employee. Because the Lord,
and you have not annexed that with the
Lord, that time, Lord, I am frankly, Lord, admitting, Lord, because for the force of interest of justice, for the interest of the client, Lord. There is a contemporary documents, Lord. I will rely on, Lord. It is their document, Lord. I'm not adding anything new.
It's time to file supplementary affidavit. Annexing documents.
Contemporary document
will be required for the for effective adjudication of the instant list.
My Lord.
Stuff. Leave sought for stands allowed. Stuff. Supplementary affidavit may be prepared and circulated by 12th June. Released on 22nd of June. Let notice be served upon the learned government pleader.
My Lord. Deep Lord.
Grateful. কেউ থাকবে না
I am
Are
here.
both parties here?
Yes. Both parties are there.
In case both parties here, then only I'll hear. Otherwise, see, all matters, the state are not there and the matters are being adjourned.
No, both parties are there. I am here.
Number 303. PCL, the council of
296
PCL will appear online.
290.
Yours is 296. अच्छा 296 টা দেখি একটু Who is your other side? 296?
I am other side. I'm for Union of India.
All right, 296. Let me see.
Petitioner retired on superannuation 30th April 2015 from the post of senior manager under the Bongio Gramin because
Bongio Gramin Bikash Bank?
Bank, yes.
Who is for the bank?
I'm not for the bank.
Then what is the use?
Union of India.
Your lordship directed to file a affidavit.
I understand. Nobody is here. Otherwise, I don't have a problem.
One Union of India.
Union of India is not the answering respondent. The bank is the answering respondent.
Not my lord.
Call the other matter. 303 or something.
303.
Which one is your matter? Which one is it?
4, 5, and 6.
Is your other side here?
Well, after vacation.
Then all after vacation. Is your other side there?
Online, he will appear online.
Doesn't matter.
303, my lord.
303.
My lord, I appear for the respondent number 227, my lord. My clerk would be there, my lord, probably with the report, my lord, because they have to file. I already served a copy of the report on them.
Where is the report?
Probably my clerk, my lord, should have been there, my lord.
Where is
Otherwise,
the
my lord,
report?
My exception.
Let the report come, then the exception. The report is not here. Well,
my lord,